Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to try to make sense of a petition for certiorari filed with the Supreme Court on behalf of a guy named Glossip out of Oklahoma. It's an interesting lesson in reading petitions and on what Paul Harvey would call the rest of the story. So Glossip in early 2000, I think maybe 2004, was involved in a murder at a hotel in Oklahoma City. He was the manager of the hotel, and he hired a maintenance guy, and the maintenance guy beat the owner to death with a ball bat. At his request, he agreed to pay him $20,000 to do this, and so he went in and beat the guy to death, and then when the cops busted him, he said, "Yeah, I'll testify against the guy who hired me." So the guy who hired him wound up with the death penalty, and the public defenders in Oklahoma City have made a killing off of recycling all of the proposed claims of error in the petition. We'll take a look first at the petition, and then we'll take a look at the Oklahoma Court of Criminal Appeals opinion, and then we'll take a look at what should be done by the Supreme Court. So this is the petition for certiorari to the Supreme Court, and it presents these questions this way. Justin Sneed was, in the state's words, its indispensable witness. Sneed is the person who bludgeoned the victim to death, and his testimony linking Glossip to the murder was central to the conviction. He only claimed Mr. Glossip was involved after being fed Mr. Glossip's name 6 times and threatened with execution. Whether that is true or not, that seems a little bit of a reach to me since he worked for Glossip. It wasn't like Glossip was unknown to him. With Sneed's credibility already tenuous, the state undisputedly hid from the jury Sneed's having seen a psychiatrist who diagnosed Sneed with a particular psychiatric condition that rendered him volatile and potentially violent, particularly when combined with methamphetamine use, a street drug Sneed was abusing at the time he murdered Barry Van Treese. In fact, the state allowed Sneed to affirmatively tell the jury he had not seen a psychiatrist. Before the Oklahoma Court of Criminal Appeals, the state confessed error, admitting that the failure to disclose the truth about Sneed's psychiatric condition, leaving the jury with Sneed's uncorrected false testimony, and then suppressing this information for a quarter century, rendered Glossip's trial unfair and unreliable. Before this court, the state has admitted Mr. Glossip is entitled to a new trial on these grounds. The petition presents the following questions: whether the state's suppression of the key prosecution witness admission that he was under the care of a shrink and failure to correct that testimony is a Brady violation, whether the entirety of the suppressed evidence must be considered when assessing the materiality of the Brady claim, whether the due process law requires reversal where capital conviction is so infected with errors the state no longer seeks to defend it. So that's how the petitioner here sets this up. It says basically, the state lied, they brought this witness in, he lied, they had to feed him the name, all of these things. Well, as you might guess, in a criminal case, there is another side of the story. So this is the order denying the motion for evidentiary hearing for discovery and a stay of execution. It was written by Judge Lewis in the Oklahoma Court of Criminal Appeals. Petitioner Richard Glossip was convicted of first-degree malice murder in violation of the law in Oklahoma County after a jury trial occurring in May and June of 2004. The jury found one aggravating circumstance, that Glossip committed the murder for remuneration or the promise of remuneration, or employed another to commit the murder for remuneration or the promise of remuneration, and she set his punishment at death. Judge Gray formally sentenced Glossip in accordance with the jury verdict in 2004. Check your watches, it's 19 years later. This court, on direct appeal, affirmed Glossip's murder conviction and sentence of death. Thereafter, he filed an application for post-conviction relief. That's basically where you raise all kinds of errors you didn't know about at the time of the trial, which was denied in an unpublished opinion. Glossip filed other subsequent applications for post-conviction relief, which this court has denied. And his execution was set for May 18th until I think it was Judge Kavanaugh granted this petition, for a petition for a stay. The Attorney General of Oklahoma has filed a response requesting that this court vacate the conviction and send it back to the district court for a new trial. The Attorney General is not suggesting that Glossip is innocent of any charge made against him and continues to believe that Glossip has culpability in the murder of Barry Van Treese. Gosh, that sounds a little different than what they put in that petition. This court's review, moreover, is limited by legislatively enacted Post-Conviction Procedure Act found at 22 Ohio Statutes Supplemental 2022. The Attorney General has joined Glossip in a motion for a stay of execution. The Attorney General takes no position on the merits of Glossip's claim in the motion. The review is now complete that the Attorney General completed. The facts of Glossip's crime were presented in detail in the opinion of the first appeal. We reiterate a few of them here. Justin Sneed, the co-defendant, pled guilty, received a life sentence without parole, and agreed to testify against Glossip. The law required Sneed's testimony be corroborated, and the jury was asked to determine whether it was corroborated in the trial court's instructions. Among the corroborating evidence noted in the direct appeal was that Barry Van Treese was the owner, Glossip worked as the manager, and lived on the premises with his girlfriend Deanna Wood. Glossip hired Sneed to do maintenance work at the motel. By all credible accounts, Sneed was under Glossip's control. In the early morning hours of January 14, 1997, Sneed entered into room 102 and bludgeoned Van Treese to death with a baseball bat. Sneed then went to Glossip's room and told him he'd killed Van Treese and that the window was broken. Glossip went to Van Treese's room to help cover the busted window, but later denied seeing Van Treese's body. Glossip told Sneed to drive Van Treese's car to a nearby parking lot and retrieve the money that would be under the seat. The envelope contained $4,000, which Glossip split with Sneed. They later recovered $1,700 from Sneed and $1,200 from Glossip. That morning, there were a bunch of other things that tied him to this crime. The case has been thoroughly investigated and reviewed in numerous appeals. He's been given unprecedented access to the prosecution's files. Yet he has not provided this court with sufficient information that would convince this court to overturn the jury's determination that he's guilty of first-degree murder and should be sentenced to death based on the murder for remuneration or promise of remuneration aggravating circumstance. His new application provides no additional information which would cause this court to vacate his conviction or sentence. So it goes through all these boxes of material that he was given access to, and then they denied his motion to amend his complaint. And so he raises 5 propositions, but the Oklahoma Post-Conviction Procedure Act limits errors to that which would have changed the outcome and claims of factual innocence. The court's rules also place time limits on raising issues in subsequent applications. These time limits in the Post-Conviction Procedure Act preserve the legal principle of finality of judgment. Claims of factual evidence must be supported by clear and convincing evidence. Factual innocence claims are the method to sidestep procedural bars in order to prevent the risk of a manifest miscarriage of justice. So, Glossip's actual innocence claim is raised in Proposition 4. In order to prevail, he urges this court to re-examine the previous claim along with what he calls new evidence, the item he relies on in his post-conviction application to meet the threshold do not show that he is factually innocent. Glossip first submits an affidavit from a guy that he had submitted before, and basically it says, "We're not convinced." The affidavit shows that Glossip is factually innocent. The affidavit merely provides impeachment evidence without showing the outcome would be different. His second affidavit is from a medical doctor, Peter Speth, who attempts to discredit the medical examiner. This is a claim that could have been raised much earlier on direct appeal, and so it's waived. There is nothing extraordinarily new in this affidavit. Further review of the matter is barred by Oklahoma law. Glossip contained claims in Propositions 1 and 2. The state withheld material exculpatory evidence. Side note here, exculpatory evidence is evidence which tends to show that he did not commit the murder or be involved in it. Even if this claim overcomes procedural bar, the facts do not rise to the level of a Brady violation. To establish a Brady violation, a defendant must show that the prosecution failed to disclose evidence that was favorable to him or exculpatory, and that the evidence was material. Material evidence must create a reasonable probability that the result of the proceeding would have been different had the evidence been disclosed. The mere possibility that an item of undisclosed information might have helped the defense does not establish materiality. Glossip claims the failure to disclose Snead's mental health treatment and that Snead lied about his mental health treatment to the jury. Though the state in its response now concedes that this alleged false testimony combined with unspecified cumulative errors warrants post-commission relief, the concession alone cannot overcome the limitations on successive post-conviction review. The state's concession is not based in law or fact. In other words, even if the state is conceding this, that could have been discovered and brought forward earlier, and it wasn't. The court then goes on to say, look, in 1997, he underwent a competency evaluation by Dr. King. The state avers that this examination noted Snead's lithium prescription. This report was available to previous counsel, so counsel knew or should have known about his health issues, mental health issues. It's likely counsel didn't want to inquire about mental health due to the danger of showing that he was mentally vulnerable to Glossip's manipulation and control. Moreover, in controlling here is the fact the issue could have been raised and should have been raised much earlier than his fifth application for post-conviction relief. The evidence, moreover, does not create an error. Defense counsel was aware or should have been aware that Snead was taking lithium at the time of the trial. Snead's previous evaluation and his trial testimony revealed that he was under the care of a doctor who prescribed lithium. His testimony was not clearly false. Snead was more than likely in denial of his mental health disorders, and counsel just did not inquire further. Glossip then comes up with this thing about a tape that was taken from the Sinclair station across the street from the hotel, and that the prosecution somewhere along the line lost. Now, they've had this case on file since 1997. It's 2023, and now they're complaining about a single videotape that was lost. Again, this issue could have been presented earlier. Counsel should have known that there were cameras at the station in reading the trial transcript and could have inquired about possible videotapes. Issues about missing tapes could be raised earlier. Glossip waived this issue. Obviously, the tape could have corroborated both Snead's testimony and Persley's testimony. Glossip offers mere speculation that the tape might have been exculpatory. He cannot show that the tape was material. Next, Glossip claims that the state failed to disclose details from witness statements that conflicted with one another. For example, the cost of the repairs, one witness said $2,000 to $3,000, another witness said $25,000. The amount spent presents a conflict, but it doesn't help Glossip. The theory was that Glossip was negligent in his job. He expected to be fired, and he chose to have Van Treese killed instead of being fired. There was money for repairs, but Glossip didn't do the repairs. This contradiction hurts rather than helps Glossip. Glossip next cites notes by the prosecutor, and Glossip speculates that the notes relate to items sold by him. Glossip's theory at trial was that the money he had was from selling some of his items rather than money stolen from Van Treese in conjunction with the murder. Glossip speculates these notes regarding money were amounts learned from Cliff Everhart. Everhart testified that Glossip sold some items for around $250 to $300. The notes do not clearly have an amount of money. There's no factual basis for this part of the claim, and the claim is waived as a claim regarding the missing tape. It could have been raised a whole lot earlier. Proposition 3 claims Snead changed his testimony. This claim is barred under our rules. Glossip raises a cumulative error claim, and a cumulative error claim is baseless when this court fails to sustain any of the alleged errors raised. And as a result, they upheld his conviction and death sentence. Because I thought it might be interesting for folks, this is the brief of an amicus curiae. In this case, the victim's family members, Derek Van Treese, Donna Von Treese, Elena Von Treese, Mileto, and the Oklahoma District Attorneys Association in opposition to the petition. And so here's what they say. Does this court have jurisdiction to review a state court's denial of a fifth collateral attack when that denial is based on the state's successive petition statute? The petition clearly does not meet the statutory criteria for consideration, and there is no claim that the state ground is inadequate or not independent of federal law. 2. Does a state attorney general's confession of error reopen an otherwise barred claim when the state court has already considered and rejected the claim and the confession, finding that the attorney general cannot waive the state attorney general can't waive the state procedural rule, and the evidence in the question was known to the defense before trial, and the evidence is not material. So they go on down here and they talk about the interest of the amici. And the interest of the amici is, on January 7th, Richard Glossip commissioned the murder of Barry Van Treese. Among many other important family relationships, Barry Van Treese was the beloved father of Derek Van Treese, husband of Donna Von Treese, and brother of Elena Mileto, the amici Van Treese family. Today, 9,645 days later, the Van Treese family has an interest in seeing Oklahoma's duly imposed sentence on Glossip carried out without further delay. Founded in 1974, the Oklahoma District Attorneys Association supports Oklahoma prosecutors in every aspect of their mission. The ODAA is interested in this case because the state court unanimously concluded that Oklahoma prosecutors properly followed all legal requirements in prosecuting Mr. Glossip, a decision which should stand. This case involves Glossip's effort to overturn an aggravated murder conviction that's nearly 2 decades old. The Oklahoma state courts have carefully reviewed it. They have concluded that Glossip is guilty and his sentence is proper. But in the last few months, a new Oklahoma Attorney General has arrived on the scene. For reasons that are unclear, he personally believes that a new trial is warranted, an opinion unanimously rejected by the Oklahoma Court of Criminal Appeals below as not based in fact or law. The Attorney General's opinion does not provide a basis for reviewing the decision below, which is fully supported by multiple independent and adequate state grounds. Any further delay would inflict enormous suffering on the Van Treese family. The court should deny certiorari. And they do a pretty good job of briefing the issues here. They talk about the issues of litigation, how the first 25 years of litigation were funded, how the last year of litigation, and I think they do a good job of saying that the new evidence Glossip asked this court to review has already been carefully considered by the highest criminal court in Oklahoma, and they've reached a fact-bound conclusion that there's no new evidence and thus no reason to doubt the integrity of the sentence and conviction. And I think that's pretty much, I think this ought to carry the day as far as everything goes at the Supreme Court of the United States. Did you notice in the petition for certiorari how clearly they made out all of these contentions? The Attorney General's behind us. He believes in this. He thinks it was a terribly unfair trial. Well, there might have been technical errors in the trial, but they didn't rise to the level of a Brady violation, and even the Attorney General doesn't think this guy is innocent. So every state has post-conviction procedures. They're sort of like an escape valve, right? They're designed to prevent a wrongful conviction once it's occurred from not being taken care of on direct appeal, so that you get one more bite in front of the state courts to fix your claim. And in this case, he raised the post-conviction relief, and then he's made 4 additional applications since then. And Oklahoma has strict rules, and the rules say you get one shot. Raise all these claims at the outset, and we'll decide them. But you can't just keep raising new ones every couple of years to delay your execution. You got an appointment, and you're going to have to get to that appointment at some point in time. So to me, when I read the application, the petition for a certiorari, what I see is lawyers who are very zealous advocates. They really don't care what the Oklahoma Court of Appeals said. What they care about is getting this guy a new trial, and they are going to put the facts in the most effective way to sort of lay the foundation for why he should be sprung. And they know that they can twist the facts around here because the Attorney General is not going to stop them. He's not going to file a response to this because he agrees the case ought to be sent back. So, since the Court of Appeals was interpreting Oklahoma law, the only thing that they can bring to the U.S. Supreme Court is due process violations. And unfortunately for Mr. Glossip, but probably fortunately for the rest of Oklahoma, he got all of the process he was due. He got his criminal trial, he got his direct appeal, he got his post-conviction relief, and he kept getting post-conviction relief applications until the 5th one, and even on the 5th one, he raises nothing new that hasn't already been taken care of by the Oklahoma Court of Criminal Appeals. Now, we have to hope, of course, that the Supreme Court will read the opinion of the Court of Appeals. I suspect they probably will because Glossip has been to the Supreme Court numerous times also, and he's always been denied. We'll have to see how this shakes out, but this is a really good lesson in reading petitions for review, particularly at the Supreme Court. When you get to that level, there is a certain measure of desperation when you're fighting for someone's life, and sometimes lawyers go just a little bit too far in search of zealous advocacy and trend into misrepresentation. Now, I don't know that that's the case here, but based on the discordance between the Oklahoma Court of Appeals opinion and the opinion of and the petition filed by these lawyers, I think it's fairly certain that maybe the state of facts that's actually the case in this case are a little different than what they put into that petition for review from the Supreme Court. Now, the Supreme Court has not acted on that petition yet. When they do, I will let you know. Thank you so much for watching. If you have the opportunity today, do something nice for someone. If you do, I can almost guarantee you that you'll have a better day. Thanks for watching. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.